Today, we are going to discuss the topic role of the League of Nations organs for protection of rights of minorities. To start with, we can say that the immediate post-World War I concerns stimulated the development of minority rights. Some of the important premises that save the League's interventions include: number 1, just and peaceful settlement of conflicts. Number 2, end to bartering of peoples and provinces at the behest of the powerful sovereigns. Number 3, rescue the world from the discredited power-centric international relations. Number 4, respect national and minority aspirations. Next, we are going to discuss the organs of the League. The League itself came into being on 10th January 1920. The League of Nations contained 4 main organs. Number 1, General Assembly, constituted by all the member states. Number 2, Executive Council, which consisted of 9 members constituted by powerful countries as permanent members, which include Britain, France, Italy, Japan and United States. The other 4 members were elected once. Number 3, Secretariat, which was based at Geneva. Number 4, Permanent Court of International Justice, which was founded in the year 1921, which its headquarters at Hague. Next, we are going to discuss the role of the organs. To address the multitude of minority issues under the League, several committees were created. One of them was the Committee on New States. The committee enjoyed 2 important privileges. First, the committee was empowered to decide if a case was to refer to the Executive Council. And second, it had the power even to completely drop a case to restrict within the juridical rights of a host state from which the minority issues were emerging. In the second situation, the committee more or less negotiated with the host government on how best to solve the matter. The second role of the committee went on to become precedent for many cases in the subsequent years. Another milestone of the League's organs included the establishment of a special minority section within the Secretariat in Geneva, staffed by international civil employees. The department dealt with the relations with the host states, including the ability to ask for additional information and advising on whether the petition was receivable. The Executive Council and the Permanent Court constituted the 2 most important organs that directly dealt with the issues of minority rights. The Council played a detrimental role in the evolution of minority rights protection scheme within the League. After a rigorous debating, the Council resolved to introduce a new approach towards addressing minority issues. The system allowed the minorities to have the right to appeal directly to the Permanent Court. Due to the differences of opinion within the League, the protection of minorities remained largely locked up and region-specific. The regionalization of League's operation was also perhaps due to the then existing Anglo-American dominance. The mediation provided by Council also ironically enabled the great powers to gradually manipulate and remove their direct responsibility for protection while still maintaining a level of influence on the issues of minority rights. Subsequently, by having no ability to appeal directly to the Permanent Court, minorities were not treated as sovereign entities on their own. The minority question, though not entirely relegated to insignificance, structural efficacy was a matter of concern, as the Council would be the only body with the power to send cases to Permanent Court. Initially, one of the biggest challenges that the League system faced was to go beyond addressing Jewish minority rights. Such structural outreach and operational ability of the League made the minorities insecure. Despite commendable headway made by the League in envisioning minority rights, it remained entangled and contested as far as the structure of engaging minority rights were concerned. The right to send direct appeals from the minority states to the League and the Permanent Court of International Justice remained unsettled for many years. The assertion of the member states to refrain from actually addressing the rights of the minorities handicapped the possibility of minorities from evolving into a sovereign entity. In order to address the opposing proposition between the member states and the minorities, the Committee on New States sent two separate proposals to the Council of Four. The Council of Four was a powerful governing body composed of United States of America, Great Britain, France, and Italy. Within the League system, another prospective attempt to address minority rights were experimented in the mid-1920s in the form of petition provision. The petition system can be regarded as a special measure designed to ensure the ability of minorities in terms of language, religion, and culture. The League of Nations protection regime superimposed some elements of collective rights and moderate majority-minority tensions. The petition system came as a ray of hope for minorities in Europe to register their potential grievances. The League received numerous petitions from the minorities. The increasing popularity of petition system became evident as by 1930, the League reportedly received 57 petitions, which jumped up to 204 in the next year. The petition did not carry much judicial and legal weight, since the Council enjoyed ultimate power to decide whether to act upon the petitions. On the other hand, the quest for minority rights was ever increasing. Towards the third decade of the 20th century, the members of the minority section of the League increased to 11 members. The League system witnessed heated debates on minority rights as to the access to the League system also increased. The minorities hope to realize their political and cultural rights through the League, especially employing petition provisions. Minorities supported the petition process for the access it provided to the League, but did not approve the committee system as they suspected to be mired in secrecy, conspiracy, and dominant states' control. The petition provision of the League, despite challenges, resulted in the deepening the role and scope of the League. The petition system enhances the power of the minority section as the League system internalized the seriousness of the need to take forward and evaluate the petitions from minorities, thereby elevating minority sections from a clerical role to an engaging role. The League system entrusted the minority section with the responsibility to analyze the petition with the following concerns. 1. Examine whether the petitions were in consonance with the available minority treaties. 2. If the petition seeks to severing relations with the state it inhabits. Number 3. Evaluate the source and authenticity of the petitions. And number 4, discourage violent languages and examine the legitimacy of the petitions. In many cases, these committees of the League negotiated with the concerned governments on behalf of the affected minorities. Despite some successes, the system suffered from a number of serious flaws. The League system by design applied only a carefully worked out set of rights to a small number of states. For example, the League quite deliberately did not achieve a general jurisprudence applicable wherever racial, linguistic, or religious minorities existed. Instead, it depended on country-specific treaties designed to facilitate the solution of minority problems in countries where, owing to special circumstances, these problems might present particular difficulties. Countries singled out and cornered by the great powers for the special restrictions of the League system bitterly resented what they viewed as a violation of sovereign equality and affront to their status as independent sovereign states. In order to overcome the inefficacy of the League, the Executive Council allowed the minorities to petition the Council. In run-up to a special Commission report headed by Tittoni, an Italian representative, an amendment of 1921 empowered the Secretary General of the League to decide on the weightage of the cases. For example, if the concerned states did not reply within a stipulated time period, the cases of petition was to refer to the Council. The petition system proved much complicated than it was anticipated. In order to protect against the abuse of the protection system, certain rules were laid down by the League in 1923, which included: number 1, follow the guidelines of the treaties in protection of minorities. Number 2, refrain from severance of political relations between the minorities and the host state. Number 3, petition could not be anonymous or come from an unauthenticated source. And number 4, acquire factual references. From the perspective of the affected member states, the petition system was hardly a relevant exercise. The apprehension was played out against the backdrop that if a member of a minority petitioned, which the host state would generally respond with an altogether different proposition. In order to reduce this apprehension, the petitioners were not informed of the comments of the accused state. In this regard, the role of Council had been to play a balancing role, for which it created a committee system. The matter therefore was sent to a committee of 3 members of the Council with the pursuing of an amendment in 1929, so that this could decide which merited to be placed before the Council agenda for discussion. The committee normally consisted of the President of the Council and 2 others nominated by him. An important precautionary condition was that none of these could come from the host state, the kin state, or a state neighboring that of the minority. The committee had 3 courses of actions. 1, it could decide that the case should go to the League Council, and 2, that the case should be settled, and number 3, it might find that a case, while not meriting Council's attention, could be dropped altogether. Although in such situations, the committee more or less negotiated with the host government on how best to solve the matter, and this became the general rule. The special minorities section handled the concerns of the host state and relations with the minorities. Now we are going to discuss the League's role and some important interventions made by the League. Since the formation of the League, several attempts were made with regard to the settlement and negotiation of minority rights. The issues concerning minority rights became one of the main areas of international diplomacy in the post-First World War scenario. To cite a few important cases of League's role and interventions in this regard, the League facilitated the conduct of a plebiscite in Schleswig in February 1920 that resulted in the agreement between German and Danish government to ensure several political and cultural rights to the minorities. Similarly, in the case of Eupen-Malmedy, linguistic rights were granted through a plebiscite. It can be said that the intervention of the League had been numerous. For example, in the case of Upper Silesia in 1920, the League appointed an expert commission which enabled Germany and Poland to arrive at an understanding to give more rights to the minorities, including, say, educational and nationality rights. The League was also involved in resolving a dispute between Sweden and Finland over the Åland Islands, an archipelago lying between Sweden and Finland, populated by some 20,000 people, almost entirely Swedish-speaking. The Council of the League set up a commission of inquiry which released its report in April 1921. On 24 June 1921, the Council formally recognized Finnish sovereignty but added that in the interest of the world peace, Sweden and Finland should negotiate further guarantees for the cultural protection of islanders and demilitarization of the archipelago. To conclude with, it can be said that the role of the League's organs, particularly that of the Council and Permanent Court of International Justice, had been significant in dealing with minority rights questions all over Europe. The League inspired in reaching an agreement between Sweden and Finland in 1921 to provide autonomy to the Swedish community of the Åland Islands. The League also began to witness powerful demands for ethno-national self-determination. From 1919 to 1920, new states were created in Central and Eastern Europe. Out of the defeated Austro-Hungarian Empire, Ottoman Empire, and Prussian Kingdom emerged a dozen new or enlarged states and flagged off the issue of plebiscite in Poland, Czechoslovakia, Hungary, Yugoslavia, Romania, Bulgaria, and Albania. The impact was so extensive that it resulted in the redrawing of Russian Empire as seen in the case of emergence of Estonia, Latvia, and Lithuania. This was possible due to the increased activity of the League that could generate a diplomatic ambience. The proactive commitment of the League on the issue led to the creation of many ethno-national states. Put simply, the role of the League as a whole towards the negotiation of minority issues stand out, distinctive and crucial, particularly through the essentialization of plebiscite principles and self-determination as well. The role of the League and the specific organs in enriching and realization of plebiscite and self-determination had been significant, as it left behind a rich heritage of a future international organization.